You're listening to an African Elements top news story for July 2025. Please visit our website at africanelements.org for more daily news. The Supreme Court ruled in Mahmoud versus Taylor on June 27, 2025, affirming that parents can opt their children out of LGBTQ+ inclusive curriculum in public schools if it conflicts with their religious beliefs. This 6-3 decision reversed lower court rulings favoring the Montgomery County, Maryland, School Board and marked a significant victory for parental rights advocates. The majority held that the school board's policy of denying opt-outs imposed an undue burden on parents' religious exercise and affected their children's religious development. Conservative groups like Moms for Liberty hailed the ruling as a victory against authoritarian schools. Maryland Republicans emphasized the importance of parental involvement in education when lessons conflict with religious convictions. The case arose from objections by a coalition of Muslim, Orthodox Christian, and Catholic parents in Montgomery County who opposed their children being exposed to LGBTQ+ content in picture books, such as Pride Puppy, which included terms like drag queen and leather. Initially, the school district allowed opt-outs, but later rescinded the policy due to concerns about absenteeism, managing requests, and avoiding stigmatization of LGBTQ+ students. The parents argued that this refusal violated their First Amendment rights to exercise their religion and control their children's upbringing. The Supreme Court intervened after lower courts denied the parents' request for a preliminary injunction to allow opt-outs during the lawsuit. The ruling was grounded in precedents emphasizing parental rights in education and religious upbringing. Justice Samuel Alito, authoring the majority opinion, cited Pierce v. Society of Sisters, 1925, and Wisconsin v. Yoder, 1972, establishing that parents, not the state, have the primary right to direct their children's education. Pierce affirmed that the child is not the mere creature of the state, while Yoder recognized the right of Amish parents to withdraw their children from school for religious reasons. Justice Clarence Thomas concurred, stating that the school board's policy imposed conformity that undermined parents' religious beliefs. Dissenting justices, including Sonia Sotomayor, Elena Kagan, and Ketanji Brown Jackson, raised concerns about the ruling's impact on public education, arguing it could create impossible administrative burdens for schools. Sotomayor contended that exposure to differing beliefs does not violate free exercise rights, and that insulating children from diverse ideas hinders their ability to thrive in a multicultural society. Critics, including Philip Alexander Downey, CEO of the Montgomery County Pride Center, condemned the ruling as an attempt to erase LGBTQIA+ children. The decision raises questions about the extent of parental challenges to curricular content, potentially extending beyond religious objections to other beliefs like pacifism or socialism. Implementing opt-out policies presents logistical challenges, including tracking students, providing alternative activities, and managing classroom disruptions. The dissent warned of a chilling effect on schools, where educators might self-censor curricula to avoid legal challenges or parental objections. This could limit educational breadth and hinder students' engagement with diverse perspectives. Concerns about the ruling's impact on LGBTQ+ students include the potential message that their identities are objectionable, leading to feelings of isolation and undermining inclusivity efforts. The Montgomery County school system introduced LGBTQ+ storybooks to reflect its diversity, but the ruling complicates these efforts, requiring a balance between parental rights and creating an inclusive environment. While clarifying parental religious opt-out rights, the ruling leaves unanswered questions about the future of public education, particularly regarding non-religious objections to curriculum content. Legal experts and dissenting justices worry that the ruling could lead to a fragmented curriculum. Future court decisions or legislative actions will be necessary to clarify the scope of opt-outs. The ruling does not specify how schools should notify parents or manage opt-outs, leaving operational questions for educators. The broader implications for curriculum design, teacher autonomy, and inclusivity in public schools remain debated. This decision highlights the tension between parental rights, religious freedom, and the state's interest in providing comprehensive education. As America's religious and cultural landscape diversifies, disputes over curriculum content are likely to continue, requiring careful navigation by school districts and policymakers. Copyright, African Elements,